2009, Cleveland, Ohio. A 54-year-old Air Force veteran, engineer, and part-time college professor is home when a man breaks down his back door. This is not the first time. It is the third time that same day. The intruder, a man on a crack cocaine binge with a history of violence, starts beating a woman inside the house. The veteran grabs his .38 revolver and fires. The intruder dies, and here is the part that should keep you up at night. The veteran was convicted of murder, sentenced to 18 years to life in prison. An Air Force veteran, in his own home, defending a woman from a convicted killer who had broken in 3 times in one day. It took years of appeals before a higher court looked at the evidence, called it overwhelming self-defense, and overturned the conviction. He was freed. Then he applied for wrongful imprisonment compensation. The state said no. He got nothing. Not $1. Not an apology. And if you think that couldn't happen to you, you need to hear what I have to say next. I'm Max, and today on Outfox Apocalypse, we are going to rip apart one of the most dangerous assumptions in America. The assumption that your home is your castle. Because the truth is, the same trigger pull that makes you a hometown hero in Texas puts you in handcuffs in New Jersey. Same gun, same threat, same family sleeping down the hall. Different state, different outcome. And I am willing to bet that most of you watching right now do not know which side of that line you woke up on this morning. Today, I am going to walk you through 7 states where defending your home can send you to prison, 5 legal myths that prosecutors use to destroy homeowners, and a 5-point checklist that could keep you out of a courtroom. If you have a family and a front door, this one is for you. Let's start with the state that has no castle doctrine law at all. Vermont, the Green Mountain State. Beautiful foliage, great maple syrup, and 0 castle doctrine statute on the books. Not a weak one, not an old one. None. Vermont relies entirely on common law self-defense principles. No statute. Now, to be fair, Vermont courts have consistently ruled that there is no duty to retreat inside your own dwelling. That much is established through case law. But here is the problem. Case law is not a statute. It is a collection of past rulings that a future judge can interpret, reinterpret, or distinguish based on the specifics of your situation. There is no clean line in Vermont law that says, if someone is in your home illegally, you are presumed justified. Every case is evaluated on its facts by whatever judge you draw. And if your facts are messy, and at 3 a.m. with adrenaline flooding your brain, they will be messy. You are relying on precedent to save you, not on a clear legal right. Vermont has low violent crime, and prosecution in these cases is rare. But rare is not the same as protected. And relying on a precedent that could shift with one new ruling is not a plan. It is a gamble. Now, some of you are thinking, well, I don't live in Vermont, so I'm fine. Hold on, because it gets worse. Washington, D.C., the nation's capital. The seat of the government that wrote the Second Amendment. And one of the most restrictive self-defense jurisdictions in the entire country. D.C. has no castle doctrine statute. It uses what legal scholars call a middle position. There is no absolute duty to retreat, but a jury can consider whether you could have safely avoided the confrontation when evaluating whether your use of force was reasonable. That means your ability to escape becomes one of the factors a jury weighs. In your own home, the irony is so thick you could spread it on toast. The city that houses the Constitution has some of the weakest protections for the people reading it. And here is the part that should terrify you. D.C. also has some of the strictest firearms regulations in the country. So, not only do they limit when you can defend yourself, they limit what you can defend yourself with. You are playing a legal game with both hands tied behind your back. Number 3, and this is the one that makes my blood boil. New Jersey. On paper, New Jersey has a castle doctrine, technically. The way a condemned building technically has a roof. New Jersey Revised Statutes 2C3-4 says you are not required to retreat in your dwelling. Sounds good, right? Here is the problem. New Jersey prosecutors are notoriously aggressively hostile to homeowners who use force. The burden falls on you to prove that you had no safe means of retreat, not on the state to prove you did. You. And if the prosecutor decides your fear was not reasonable enough, or that you could have locked yourself in a bedroom and called 911 instead, you are looking at charges. Someone left a comment under a video like this that said, "In New Jersey, you most likely need to be shot first and then live to shoot back in order to get a justified shooting." Hundreds of people liked that comment because it's not even satire. It's a survival guide. But wait, it gets better. Some interpretations of NJ law suggest you should verbally warn an intruder before using force. Think about that. Someone kicks in your door at 3 a.m. and the state wants you to announce your intentions like a hotel concierge. "Excuse me, sir. I'm armed and I'd prefer you to leave," in the dark, with your heart rate at 200. And then there's the ammunition. Hollow point ammunition is restricted in New Jersey. You can have it at home, at the range, while hunting, and during direct transport between those locations. That's it. So, the very ammunition that reduces overpenetration through walls, the kind that actually protects your family from stray rounds, the kind that every law enforcement officer in the country carries, is treated like contraband if you're a civilian in the Garden State. In Texas, castle doctrine means your home is your castle. In New Jersey, your home is your liability. Let me take a breath here, because we are not even halfway through this list, and I need you to understand something. Everything I have said so far is publicly available law, statutes, case history, prosecutor patterns. I am not giving you legal advice. I am a fox with a physics degree, not a lawyer. But even I can read a statute. And what the statutes say in these states should concern every single person watching this who has a family and a front door. Now, pause this video for 30 seconds. Pull out your phone, type in your state's name and the words Castle Doctrine Law. Just look, because what you find in the next 60 seconds might change every decision you make from this point forward. Alright, let's keep going. Number 4. Maryland. Maryland is an interesting case because the law itself is not the worst. Maryland does recognize self-defense in the home, and there is no explicit statutory duty to retreat inside your dwelling under current case law. But, and this is a big but, outside the home it is a different story. Maryland is a duty to retreat state in public, and prosecutors in Maryland have a well-documented pattern of leaning toward charges in self-defense cases. One viewer wrote, "I'm in Maryland. He would have had to run inside of my house shooting for it to have been justified." That is not how the law reads. But that is how the law feels when you are standing in front of a prosecutor who wants to make an example. Number 5. New York. The Empire State has a castle doctrine, technically, under Penal Law Section 35.15. But New York has a trap that no other state has. Even if your shooting is completely justified, even if the intruder had a weapon, even if he was in your home, if your firearm is not properly registered, you get charged with a felony weapons violation. The justified shooting becomes irrelevant. A man in Brooklyn shot an intruder who broke into his home, justified. But his gun registration had lapsed. He was charged. Another case, a bodega worker was attacked by a man who jumped the counter. He grabbed a knife in self-defense. Justified. He was still arrested and charged. The charges were eventually dropped after massive public outcry, but he spent time in jail first. Here is what makes New York dangerous. It is not always the self-defense law itself. It is the layers of other laws that trip you up. The prosecutorial culture. In upstate New York, a jury might understand why you reached for a shotgun at 3 a.m. In the 5 boroughs of New York City, that same jury pool comes from a very different world. Same state, same statute. completely different interpretation. And you do not get to pick your jury. Number 6. Massachusetts. The Commonwealth of Massachusetts requires you to use reasonable force, and, outside the home, you have a duty to retreat if you can do so safely. Inside the home, the law provides some protection, but the burden often falls on the homeowner to prove there was no safe retreat available. Here is the pattern you should be noticing by now. It is not just about the words in the statute. It is about who has to prove what. In a strong castle doctrine state like Texas, the law presumes that if someone is in your home illegally, you had reason to fear for your life. In Massachusetts, that presumption does not exist in the same way. You have to build the case that your fear was justified, your force was proportional, and you had no other option. After you just survived someone breaking into your home at 3 in the morning while your heart rate was 200 beats per minute and your hands were shaking. Good luck building a legal argument in that condition. And a bonus that didn't make the main list but deserves a mention. Rhode Island. Rhode Island has a castle doctrine unless your attacker lives with you. The moment the threat is from a roommate, a partner, a family member, castle doctrine vanishes. Now think about the statistics. The majority of violent assaults happen between people who know each other. The very scenario where you are most likely to need self-defense is the exact scenario where Rhode Island strips your protection. And finally, number 7. And we saved this one for last because it is the one that keeps every homeowner in America awake at night. Minnesota. And here is a detail that will make you want to throw something. In March of 2025, the Minnesota legislature voted on a stand your ground bill. It needed 68 votes to pass. It got 67 to 65. 1 vote short. If one single person in that building had voted differently, every homeowner in Minnesota would have clear legal protection today. 1 vote. And now every homeowner in that state is still playing legal roulette. Minnesota has no stand your ground law. Its self-defense statutes require reasonable force, with a heavy emphasis on proportionality, and prosecutors have wide discretion in interpreting what reasonable means after the fact. That means your survival decision made in 2 seconds at 3 a.m. gets analyzed for months by lawyers in a fluorescent lit office. And if they decide you used 1 round more than necessary, or that you should have retreated to a back room, or that your fear wasn't reasonable enough, you are the one in handcuffs, not the person who broke into your home. You. 1 vote. That is how close Minnesota came to fixing this, and 1 vote is all it takes to keep it broken. Now, I know this is going to start a war in the comments. Good. Because the war in the comments is better than the war in court that you weren't prepared for. Let's talk about the 5 myths that put people in prison. Because these are the things people believe with absolute certainty, and they are dead wrong. Myth number 1. Your property line equals your castle doctrine protection. Wrong. In the vast majority of states, castle doctrine applies to your dwelling, your house, sometimes your car, sometimes your workplace. But your front yard, your porch, your driveway, those are legally a different universe. Someone wrote a comment that said, "Castles have gates and walls. If they come over the wall, they're toast." 457 people liked that comment, and that comment could get every single one of them prosecuted, because your fence is not a castle wall in the eyes of the law. There is a massive legal difference between someone standing in your yard and someone standing in your living room. Massive. Myth number 2. Warning shots are legal. They are not. In most jurisdictions, a warning shot is a felony. It is reckless discharge of a firearm. The legal logic is simple. If you fire a weapon, you are using deadly force. If you did not aim at the threat, the prosecutor argues you were not actually in danger. And here is the part nobody thinks about. That warning shot goes somewhere. It goes through a wall, it goes across the street, it goes into a neighbor's bedroom. One well-intentioned warning shot, and you are facing felony charges while the intruder walks free. Someone once said, "There are no such things as warning shots. Just a shot where you missed, that person understood the law better than most lawyers explain it." Myth number 3, dead men don't testify. This one gets repeated in comment sections like it is gospel, and it is the most dangerous myth on this list, because the dead man does not need to testify. The forensic evidence testifies for him. The angle of entry, the distance of the shot, the number of rounds, whether he was facing you or facing away, whether your shots hit him while he was standing or while he was on the ground, the 911 recording of your voice, your prior social media posts about what you would do to intruders. And yes, prosecutors do search your Facebook, your Instagram, your Twitter, that tough guy post you wrote 3 years ago about how anyone who breaks in is leaving in a bag. That is Exhibit A in your murder trial. The dead man does not testify, but everything else does. Myth number 4, stand your ground works everywhere. It does not. As of right now, roughly 13 states still require a duty to retreat in some form. And even in states with stand your ground, the law only applies where you are legally present and when you are not the initial aggressor. Stand your ground is not a blanket license. It is a specific legal defense with specific requirements, and if you do not meet those requirements, it evaporates. Myth number 5. And this one is personal. I'll just say I feared for my life and it's over. No, it is not over. I feared for my life is the beginning of the legal analysis, not the end. You must demonstrate that a reasonable person in your position would have felt the same way. You must demonstrate that the threat was imminent, not theoretical. You must demonstrate proportional force. And you must demonstrate that you did not provoke, escalate, or set up the encounter. A retired cop left a comment that said, "If I'm ever involved in a self-defense shooting, I will not say a word to the police." 737 people like that. A SWAT trainer replied, "It makes no difference how innocent you are. Do not talk to the police." These are people who spent their entire careers on the other side of that badge, and they are telling you to shut your mouth. Think about what that means. Now, some of you in Texas are going to say this doesn't apply to you. And you're right. For now. But legislation changes, and the state you're in today might not be the state you're in tomorrow. One election, one ballot measure, one Supreme Court ruling. That is all it takes to move the line. And if you didn't prepare while the law was on your side, you will not be ready when it isn't. Here is what you actually need to do. 5 things. And I want you to write these down or save this video because you will need this. Number 1. Know your state's law. Not what your buddy told you at the range, not what you read in a comment section. The actual statute. Print it out, read it. Understand the exact conditions under which you are protected and the exact conditions under which you are not. If you cannot explain your state's castle doctrine in 2 sentences, you do not know it well enough. Number 2. Script your 911 call in advance, right now, before anything happens. Your script is 5 sentences. Someone broke into my home. I was in fear for my life. I had to defend myself. I need an ambulance and police. I will cooperate fully, but I need to speak with my attorney before giving a statement. Memorize that. Tape it to the wall next to your bed if you have to. Because after a shooting, your adrenaline will be so high you won't be able to form a sentence. One commenter, a guy in his 50s, said his adrenaline spiked so high during a confrontation with a neighbor that he was barely able to talk. 325 people understood exactly what he meant. Number 3, get self-defense legal insurance. Companies like U.S. Concealed Carry Association, CCW SAFE, Armed Citizens Legal Defense Network, Plans range from about $13 to $50 a month. A self-defense trial costs between $50,000 and $300,000 on average. $150 a year for legal coverage is the cheapest insurance you will ever buy. Do the math. Number 4. Clean up your social media right now, today. Go through every post you have ever made about home defense, intruders, guns, or castle doctrine. If it sounds aggressive, delete it. If it sounds like you want someone to break in so you can use force, delete it. If it sounds like something a prosecutor could read in front of a jury to paint you as a trigger-happy vigilante, delete it. Your posts are not private. They are evidence. Number 5. Consult a local attorney. Not a YouTube video, not a podcast, not me. An attorney licensed in your state who specializes in self-defense or firearms law. One consultation, 1 hour. Usually $100 to $300. That is the price of knowing exactly where you stand before you ever have to stand your ground. Now, for the 15 to 20% of you watching from outside the United States, let me give you some context on how different this gets. In Canada, self-defense is legal under Criminal Code sections 34 and 35, but the way prosecutors enforce it makes American restrictive states look like Texas. A man in Hamilton, Ontario, shot someone who was stealing his truck from his driveway. He got 8 years, not for murder, for manslaughter, for protecting his own property on his own land. In another case from 2025, a man fought off an attacker who came at him with a crossbow and was charged with aggravated assault. A crossbow. He defended himself against a crossbow and still got charged. The charges were eventually dropped after investigators reviewed the evidence, but only after he went through the system, hired lawyers, and lived with a criminal charge hanging over his head for defending his own life. A young man in Toronto shot an intruder who broke through his door with 3 others to rob his family. He was charged with murder. Defending your home in Canada can cost you $100,000 in legal fees, even if you win. And Canadian firearm storage laws require your gun to be locked, unloaded, with ammunition stored separately. By the time you unlock, load, and rack, the intruder has already made his intentions very clear. Or you are already on the floor. In the United Kingdom, the law says you can use reasonable force. And the word reasonable is doing a lot of heavy lifting. A farmer named Tony Martin was burgled 10 times. After the 10th break-in, he shot one of the intruders. He was initially convicted of murder and sentenced to life. On appeal, the conviction was reduced to manslaughter, and the sentence cut to 5 years. He served 3. But here is the part that makes people lose their minds. The surviving burglar, the career criminal who helped break into Martin's home, was granted legal aid to sue Martin for damages. The lawsuit was eventually withdrawn, but the fact that a repeat offender was given taxpayer money to sue the man he robbed 10 times tells you everything you need to know about how the UK views the balance between criminal and victim. Someone from the UK shared, "The police told me not to hit the intruder too hard. Hundreds of people reacted to that." Because in Britain, the legal expectation is essentially that you should politely inconvenience the person robbing you and then let the system handle the rest. An elderly Canadian viewer mentioned that he carries a 20-inch steel dog chain because actual self-defense tools are illegal where he lives. 75 years old, carrying a dog chain for protection. Think about that the next time someone tells you the Second Amendment doesn't matter. And that brings us back to the core problem. The same action, the same desperate moment, the same human being protecting the same family. And the outcome depends entirely on which side of a state line or a national border you happen to live on. That is not justice. That is geography. And geography is something you can either understand or ignore, but you cannot argue with it after the fact. One of the highest rated comments I have ever seen on a self-defense video was this. A man said, My uncle waited in his living room, knowing that 2 guys were breaking in. The criminals were shot. Later, I asked why he waited. He said, "Because it is cheaper to replace a door than to spend 10 years in prison." 2,147 people liked that comment. Because his uncle understood something that most people do not. Knowing the law is not about being passive. It is about being strategic. It is about surviving the legal aftermath the same way you survived the break-in. Bottom line, 3 things you walk away with today. 1. Your state's castle doctrine is not what you think it is. Look it up tonight. 2. Everything you say, post, and do before and after a home defense situation is evidence. Act accordingly. 3. The cheapest thing you can buy for home defense is not a gun. It is knowledge. Knowledge of your state's law, knowledge of what to say to police, and knowledge of what not to say on the internet. If you want to keep your family protected when the system doesn't make it easy, subscribe. I cover what others won't touch, and I back it up with data, not opinions. Everything in this video is for educational purposes only. Laws vary by state, by county, and sometimes by city. What is legal in Texas may put you in prison in New Jersey. Always check your local laws before purchasing, carrying, or using any self-defense tool. And always consult a qualified attorney before making decisions about lethal force. I'm a fox with a physics degree, not a lawyer. But I read the statute so you don't have to. Stay safe. Max out.